Hello, I'm Vernon Kellogg, and the Board of Registration in Medicine has violated my natural rights and caused me harm. On September 17th of 2007, the board sent a subpoena to me asking for all my records. The next day I called them and asked why, and they would not tell me. I asked that they would respect my natural and constitutionally protected rights. I reminded them that it was their constitutional duty to notify me of whatever complaint they had. I reminded them that I had a right to face my accuser. They told me they had an open complaint. I asked what that was, and they wouldn't answer. Instead, they referred me to the website for a definition. There is no definition of an open complaint on the website. Mass Declaration of Rights 12 states that no subject shall be held to answer for any crimes or offense until the same is fully and plainly, substantially, and formally described to him, or be compelled to accuse or furnish evidence against himself, and every subject shall have the right to produce all proofs that may be favorable to him, to meet the witnesses against him face to face, and to be fully heard in his defense by himself or his counsel at his election. In this Declaration of Rights, there is no distinction between criminal or civil offense. And there is no exception for an administrative agency. I asked for my rights and they ignored me. On September 19th, I wrote them again, asserting my rights, and there was no reply. 10 days after the subpoena, on September 27th, I met in person with an investigator and a lawyer at the board. They presented me with an injunctive order from another case and told me that it applied to me. I told them that it could not apply to me. I reminded them that they had to respect my rights to notice of the complaint and to the nature of the complaint and other due process rights. The lawyer told me that the constitutions do not apply, and I told her that they certainly did apply. She asked me for my medical license, and I told her no. I wished to speak with her superior. It now has been 10 days since the subpoena, and they have not told me the nature of any complaint, and that my rights and the constitutions do not apply. Also, lying to me is not due process of law. They told me I could meet with Dr. Crane on October 3rd, 6 days from then. I wrote him on October 1st in anticipation of the meeting, but there was no reply. On October 3rd, after working all night in the emergency room, I drove into Boston for the meeting with Dr. Crane. Upon my arrival, I was whisked into a small room with bars on the window and a guard at the door and told I couldn't leave. I was frisked and relieved of my small pocket knife. I was not yet told any reason for their actions. This was 16 days after the subpoena, and I still haven't been told the nature of the complaint. I was given a 1-inch stack of papers and told to read it because we were going to have a hearing in 15 minutes. I couldn't read that much in such a short time. I was ushered into a large room set up like a courtroom. They asked a few questions that I had difficulty hearing, and in a few minutes, I was sent back to the small room with bars on the window and the guard at the door. They came and told me that my license to practice medicine had been suspended, to give up my wallet card, and not to go home and commit suicide. Declaration of Rights 12 does not allow that action. Their own regulations say that a statement of allegations must be issued prior to an adjudicatory proceeding. They sent a statement of allegations to me on October 4th, the day after I just described. They didn't even give me a statement of allegations when I was there on October 3rd. Those actions clearly are not due process. They lied to me. They said we were to have a meeting with Dr. Crane. Then when I get there, they tell me we're going to have a hearing and I can't leave. Then the hearing turns into a proceeding for a summary suspension that I don't find out until after it occurs. Lying, deception, and trickery are not part of the due process of law. I am not a criminal, and I shouldn't have been treated like one. The board has held up their policies and guidelines and told me this is the law. They can only be but color of law, since Declarations of Rights 30 forbids any part of the executive branch from making laws. They have treated me like a criminal, even though the situation has been some minor variances with their policies and guidelines. You can't say that someone didn't follow specific guidelines, and because the guidelines were written following a generality in the law, that someone has broken the law. From the beginning, I should have been given notice and the nature of the complaint and had it fully and plainly, substantially and formally described to me. I should have been given adequate time to prepare a defense. That's what Declaration of Rights 12 guarantees to me and everyone. The constitutions apply always and everywhere, but they were denied or ignored at the Board of Registration in Medicine. They were denied emphatically at the Division of Administrative Law Appeals, and they were trivialized at the Single Justice Court. The Supreme Judicial Court for the Commonwealth is the last bastion of defense for individual rights in the state, and that is why I am here. What is very clear is that the Board of Registration in Medicine has used administrative law to bypass and exceed the limits placed on them by the constitutions. The constitutions make no exceptions for administrative law. Therefore, I know that the constitutions apply to the board and to all administrative agencies. Due process of law is a chain of events, and if any link of that chain is broken, due process fails. The broken links of the chain of due process are scattered all over the floor from the early days of the controversy between the Board of Registration and myself.
Thank you.
Hello, may it please the Court, Zuleikan Walker, Assistant Attorney General on behalf of the Board of Registration in Medicine. Dr. Kellogg has failed to establish any basis for reversal of the Board's decision in this case. Dr. Kellogg...
Could you explain to me just the circumstances surrounding the temporary suspension of his license to practice medicine?
Sure. The temporary suspension took place on October 3rd. That was the hearing. And the regulation...
Given notice of that hearing, or how did that work?
Yes, well, he came to the October 3rd hearing.
I mean, but was he given advance notice?
Of the October 3rd hearing, yes. I don't know that he was told that it was his summary suspension hearing. I know he was told of the hearing. He was there at the hearing.
He described he was there for a meeting.
Yes.
And that turned into a summer suspension hearing that he had no
He had no notice. Yeah, he may not have had notice that it was a summary suspension hearing, yeah. The regulations do not provide, nor does the Constitution provide him with the right to notice of a summary suspension hearing.
I thought there was a right to a hearing on that.
There's a right to a hearing after the summary suspension has been issued. So one of the questions that the single justice did address below was whether or not this court has actually specifically addressed with respect to the board's regulations whether or not there is right to notice of a summary suspension hearing. And that specific question hasn't been addressed by this court. However, I would point the court to the case of Doopy B. Barron, as well as El Rodi, which was a single justice decision attached to to the addendum to my brief. And in Doopy B. Barron, the question was addressed with respect to the due process requirements around a summary suspension. In that case, it was a hospital's decision to revoke temporarily a physician's right to practice. And in that case, the court discussed that in a situation where there is a threat to the public, a reasonable threat to the public that is of concern, and there is a degree of pre-deprivation procedures, that a summary suspension is permissible so long as post-deprivation procedures are in place.
Describe that again. A degree of pre-deprivation procedures.
Yeah, that would assure, I believe the language was, that would assure within reason that the government's action in that case would not be based on as any kind of significant error. And in this case, there was, I think, a several-month investigation. There were numerous documents that were given. There was a presentation given to the board with all of the evidence. And so I think that would meet the test of a degree of pre-deprivation. Maybe I shouldn't have used the word procedures, but pre-deprivation process that the government entity would go through to make sure that its action in the summary suspension was sufficiently protective given the balance of the rights.
But was there an investigation, did you say, that had preceded this?
Yes, for several months.
For several months. And when was the subpoena to which the doctor referred?
September 17th. So he was subpoenaed. They began their investigation in April of 2007. They issued their subpoena on September 17th. And the summary suspension hearing was October 3rd.
And when was the first point where he received a statement of the allegations?
After the October 3rd hearing. It was at the latest October 4th.
Was there another hearing after assuming he didn't get any advance notice, would he have been entitled to another hearing on the summary suspension?
Yes, Your Honor. Yes, Your Honor. So the regulatory procedures are that after a summary suspension has been issued, within 7 days, the physician is entitled to a hearing. A hearing was scheduled for October 11th, and he waived his right to that hearing.
Okay.
So in that context, under this Doopy B. Barron standard, as well as the discussion in the El Rodi case, certainly any due process procedures he was entitled to, and I don't think there's any dispute here that he was entitled to a due process procedure. They were granted, and he waived his rights to those.
And you said he waived it by doing what?
By declining to participate in the October 11th hearing that was scheduled for him, which would have been the hearing at which he could challenge his summary suspension.
By declining meaning not showing up, or declining meaning a written declination?
Written declination. He was represented by counsel at that time.
At that point, I know he was represented at the hearing by counsel, ultimately at the hearing on the merits,
Yeah.
but he was represented by counsel back in October as well.
Yeah, and actually, the actual hearing, the adjudicatory hearing that is before this court today, he was pro se. He and his attorneys parted ways, but at the time of after the statement of allegations issued and he received that, he did engage an attorney, and that attorney waived his right to the October 11th hearing.
Could you say again, I know you told Chief Justice Ireland when that statement of allegations was sent?
It was issued on October 3rd. I believe it was sent to him on October 4th. But I believe in his own statement of facts, he knew at that time they may have come out of the October 3rd hearing and said your license has been suspended, but I believe a written notice went out on the 4th.
Was it really a mystery to him as to what the basically underlying problems were?
I think it would be hard to say that it was a mystery. They did meet with him and state...
Prior to the temporary suspension?
Correct, yes. So they met with him on September 27th and asked him at that time to bring his records of drug dispensation records, his medical records, and discussed with the fact that he was under investigation.
There had also been a DEA investigation.
Correct.
How does that work time-wise with respect to what the board did? Was it before the board's?
It was before the board. The DEA, I believe, was the basis for the board becoming alerted to his practices.
And what had happened at the DEA? Was there a resolution of some sort before the DEA, a fine or something?
The DEA revoked his ability to dispense controlled substances,
But is
according to Dr. Kellogg.
Is there anything in the board's regulations that require a physician who has been investigated by the DEA to inform the board?
In the licensing applications, there is a question about whether or not, I don't believe it's an investigation, but whether or not a government entity or perhaps licensing entity, but I believe it's government entity or regulating authority has sanctioned in some way. So I don't believe an investigation is necessary, but sanction. And he actually falsely submitted information on his application in that regard. So the actual basis for the board's decision to revoke his license doesn't actually seem to be in dispute here. The basis for the board's decision to revoke his license was his failure to obtain professional malpractice insurance, his submitting false information in his licensing applications, his violation of Chapter 94C, which is really quite significant around record keeping and dispensation of controlled substances, and also very significantly his refusal to cooperate with the board in its investigation. For all of the reasons stated in my brief, the constitutional issues that he's raising, sort of separate and apart from whether or not the board's decision was actually supported by the evidence, the constitutional issues he's raising, settled law really establishes that there was no constitutional violation in this case. Dr. Kellogg has, or rather this court has acknowledged that the legislature, through the board, has decided that the practice of medicine requires regulation in order to protect the public health and safety and welfare. And Dr. Kellogg chose to engage in this profession and become licensed, and thereby subjected himself to the legislature's desire that there be a regulating entity. Certainly, Dr. Kellogg is free to hold his beliefs and opinions and to believe in them very passionately, which he clearly does. But to practice medicine in a situation where the legislature has deemed it important to regulate, the board properly found you can't do both. You can't flout the authority of the board and decide to practice the way you will. And for all those reasons and the reasons stated in my brief, if the court has no questions, I will rest on my brief.
Thank you.
Well, I please stand.